Thank you for joining us, for taking time out of your day. My name is Hillary Fiorella. I'm the Executive Director of the American College State Farm Center for Women in Financial Services, and it is my pleasure to welcome you to today's webcast, The Convergence, Special Needs Planning and Women. Today's presentation is a joint effort between the American College Alumni Association, our Women's Center, and the Center for Special Needs. As we know, this topic is near and dear to so many. We have a lot of important information to cover today. Without further ado, I'm pleased to introduce my colleague, Tom Brinker, Director of the college's Mass Mutual Center for Special Needs, and he'll be our moderator today. We'll be joined by Linda Commel-Brown, Bleakley Financial Group's Special Needs Team, Life Team. She has extensive experience. She's an alumni of the college. She has her CFA, CHSNC. She's a certified divorce financial analyst. And we will all be joined by Leslie Mihalik from McAndrews, Mihalik, Connolly, Hughes, and Ryan PC, where she's the supervising partner of Trust and Estates and manages estates, special needs, disability planning, guardianship, and you'll hear so much more about Leslie's experience on the call. So thanks for joining us today.
Okay, welcome everyone. Again, elated to be here with all of you. Two very dear friends working with us today, Linda and Leslie, whom I've had the distinct pleasure of knowing for quite some time. Leslie probably far longer than anyone needs to know. That I've pretty much grown up with Leslie, or my son has grown up with Leslie. But today we're going to cover 4 incredible topics. And we really hope the time permits adequate coverage, because we could have a webinar on each and every topic. We're going to talk about creation of a life care plan, insurance needs, ways to plan prior to a divorce, perhaps during a divorce, and post-divorce considerations, and understanding dual guardianship risk. And I realize, for one, I know Linda does, Leslie, these are emotionally charged issues. So let's take a look at our first topic. But even before jumping into that, Linda, if you can share with us a little bit about your background, your family.
Right. So I'm looking for that family slide. So
there it is.
There it is. When I say I know special needs, I wanted to share a very brief snapshot of our family's journey and what it's been like raising these 5 children. I am both academically and financially trained to work with the special needs families, but my greatest life learning is my family's personal story. And if I look at our 5 kids, we have been touched by a near fatal car collision, Crohn's disease, learning disabilities, multiple concussions, attentional issues, depression, and last but not least, that adorable little munchkin sitting on my husband's lap has profound nonverbal autism. He's actually a level of 8 out of 8 need on the government scale. And so all these kids have multiple strengths, multiple accomplishments, but it's been a very long journey. And as the mom, I certainly ate most of the worry pie. I can't say there's been a lot of peace in the home or a lot of downtime for us to relax as parents, but thankfully, my husband and I agree on a couple of principles, which has worked for us. Number 1 is we need to meet our kids where they are. It's our job as parents to help the kids. Secondly, to be the best that they can be, no matter what the genetics, no matter what life events they've faced. We needed to roll up our sleeves and get really busy being their advocates. I have a motto that every second counts when you have a child with special needs. And that all said, planning is really painful. You're forcing yourself to look into the future, to a time when you're gone and you can no longer control all the variables that affect your child's safety, their wellness, their stimulation, their quality of life. And we all know in our hearts, no one is going to care for our kiddos like we have during our lifetime. So it is this life care plan that is the best possible proxy to what we can give our kids during our lives. So I was the one who did the research, spoke to the school district, the doctors. Because of my background in finance, I did a lot of the special needs planning and all the other financial planning that was necessary to ensure that they have the best possible future. We mindfully divided and conquered. That was an essential formula. It's complicated, it's volatile, equitable division of roles, whatever that is, it's dynamic, it's certainly not static. And children with special needs and mental health conditions can really take their toll on the entire family and certainly tear parents apart. So in order to ensure the best possible life for our special needs children after parents are gone, let's talk about best practice, which is known as the life care plan for the special
Linda,
needs
what a
child.
great segue. Beautiful family. Linda, we'll
Thank
kick off
you.
with you. The next slide, please. That most advisors know that having a letter of intent and a special needs trust are paramount in special needs planning. We've all heard these are the benchmarks that at bare bones minimum we should have. But Linda, please share with us why that is simply not enough. And what is the business case for this life care plan?
Right. So first of all, life care plans have actually been around for a long time. They've been around for about 30 years. They've been used in catastrophic personal injury cases. So they've been used in the insurance space and the rehab space, but they are being used increasingly in the special needs case, because a letter of intent and a special needs trust, while they're integral parts of life care planning, on their own, they're just not enough. I would say that it's easy to confuse the life care plan with the letter of intent. The letter of intent is pretty much, it's static. It's a written record. It focuses primarily on documenting the historical background of the special needs child and their care. You assign responsibilities and tasks for that care. Certainly a letter of intent provides an understanding of your child's medical, developmental, other needs, maybe your vision for, their future vocational interests, what a productive future they could have. But I've heard it said a few times that a life care plan is a letter of intent on steroids. A life care plan is a dynamic living process. It is a comprehensive view of everything that is needed for the child in granular detail. It provides critical financial parameters. It provides real-time snapshots into the actual balances and constraints facing the provider team. And questions that are addressed in the life care plan would be things ranging from budgetary allocations to different categories of life needs, activities. You specify, situations and environments that calm or upset your child, or amuse and engage your child. You can give part of the life care plan to the guardian of the person. You can give part of the life care plan to the guardian of the estate. Certainly would include favorite recreational destinations, clothing. I would say that on the expenses, on the income side, maybe if you could go on to the next slide, the life care plan details the financial resources that are funding sources for all of the major supports and activities for the child. I mean, those would be things under assets like the 529, the abiiy, SSI, SSDI, and of course also the uses of the funds, which would be actually on both sides of the slides, basically the expenses. That would be therapy, leisure, recreation, entertainment, taxes, transportation. It's a daunting process. And if you do need help organizing and writing a life care plan, there actually are specific life care planners available, largely through personal injury firms, but a trained financial advisor could certainly also help. And I just wanted to make mention that, in this age of technology, there are a few new specialized tools to streamline the life care process, the life care planning process. My family is currently looking at a technology platform for life care planning called Hope Trust. It's a smartly navigated collection, reporting, dashboard, lots of videos that you can watch, wonderful support system, excellent demos. So, that's something to consider as well. Remember, with any plan, the life care plan is only as good as the thinking that went into categorizing the activities and the uses of the resources and the accurate projection of the child's lifetime financial and medical needs. So that's
Very
what we're
good.
looking at. Daunting, but necessary.
No, unquestionably, Linda, overwhelming. And I know you had a slide regarding budgetary, so we could show that again. And maybe this slide before, Brooke, there it is. So tracking income and expenses for a life care plan. And I know this is being recorded, but some really great pointers here. I want to turn over to Leslie for a few seconds here. Leslie, if you can take a second, reflect upon what maybe some of the top items that we need to consider when building a special needs plan or even a special needs estate planning / trust series of arrangements.
Absolutely. And thanks, Tom.
Thanks,
That's an excellent question. As you stated, having a special needs trust is truly paramount and is such an essential part of any plan when a family has a child with special needs. So whenever you do have a client who has a family member or child with special needs, it's just essential that they have proper estate planning in place. And that includes either a third-party funded special needs trust or a supplemental needs trust. It's the same thing. Those two terms are interchangeable. I'm still so surprised by how many clients I see come through my door who still think that they need to disinherit their child with special needs. We have clients who may want to leave money to another sibling, child without special needs, let's say Sister Susie. And while Sister Susie could have the best of intentions and could very much love her sibling with special needs, when we leave money to that Sister Susie, we just don't have any guarantee that it will be used on behalf of the child with special needs. What if Sister Susie is involved in a divorce, or if she goes through bankruptcy? What if she's a spendthrift, has addiction issues, or has a spouse who may want to spend the money on houses and vacations? There's just really no guarantee how it will be used. So by coordinating your will with a proper supplemental needs trust, we can ensure that a fund will be created for the child with special needs, and that fund will be there for that child during his lifetime to enhance his quality of life and to still allow him to be eligible for public benefits. Those trusts can be either testamentary, meaning that they are contained inside the actual will, or they can be drafted as an inter vivos trust document, which exists outside of the will. The inter vivos trust allows the opportunity for lifetime gifting into that trust, and it also allows other family members to name that same trust in their will. So that way we can avoid multiple family members having to do costly estate planning. Another huge consideration that people need to think about is who will be the trustee of this trust. The trustee is the gatekeeper, the one that's going to allow distributions from the special needs trust or say, no, this is not a good idea. So in many cases, it can be a family member, but there are cases where families might want to look into having a corporate trustee, either a bank or a trust company. For example, if the child with special needs has mental health illness, that can make familial relationships extremely difficult. It can just be fraught with all different kinds of issues. And that is a case where, maybe we don't want to put a sibling in as trustee and put that sibling in charge of holding the purse strings too. So maybe we do investigate a corporate trustee in a case like that. Obviously, all of these things are very case by case and very dependent upon the individual family circumstances.
Okay, we can move on to the next slide. Now, before jumping in this, I want to mention one thing too. Monetary risk to public benefits. Leslie, this is an issue which a lot of parents bring to our attention. And of course, like yourself in practice, I cannot tell you how many parents have children that qualify for public benefits, yet never seek them, do not know how to seek them, or feel that they should not seek them. So if you could share with us, what is the risk to public benefits here, that would be great.
Yeah, so Tom, if we don't have a proper estate plan that makes sure that any monies that would be left for the child with special needs, we want any of those monies to be directed directly into the supplemental needs trust or third party funded trust. And the reason to do that is that's really the major vehicle that's going to protect that child's eligibility for public benefits for the remainder of his life. And that eligibility for public benefits is so important. I just cannot overemphasize how important it is to maintain eligibility for those benefits. On the slide, we've listed two major public benefits that we're concerned with. Supplemental security income through the Social Security Administration. That's a benefit that the child can qualify for if they are disabled, meaning that they're unable to work enough and maintain enough income to support themselves. So they have to be both disabled, but also have to have very, very limited resources. In fact, a person can only have $2,000 in his own name and still qualify for SSI, supplemental security income. So as you can see, this type of planning is not just for rich families, it really impacts all families. With supplemental security income, that entitles the child to a check each month through Social Security. The maximum amount for 2021 is $794 per month. And then your state may have a small supplement on top of that as well. Along with SSI, we are also extremely concerned about medical assistance, or Medicaid as it's known federally. Again, the two terms are interchangeable. But Medicaid is the source of healthcare coverage, and it's just so crucial that we maintain that. Medicaid is truly the broadest source of healthcare coverage that there is. And along with Medicaid, each state has Medicaid waiver programs as well. And those are the programs that provide either community living arrangements or certain residential funding, but they can also provide in-home supports that allow a person to stay in the community. So for example, if you have somebody with extreme physical disabilities, but who is still able to live in a condo, the Medicaid waiver programs can provide any supports that they need in order to assist them to live safely in their own home and be able to stay in the community. So these benefits are just so important. And we urge parents to go ahead and apply for benefits when the child turns 18. There's a lot of reasons for that kind of go outside the scope of our talk today, but we want to be sure that the parents are moving forward with those application processes and that we get that moving as soon as possible. So once the child is over 18, no parental monies are deemed to that child for purposes of SSI eligibility. We're only looking at the money in the child's own name. So as long as they don't have more than $2,000, then the parents should go ahead and apply for benefits at that time.
Again, Leslie, thank you. That's another topic for another hour, just delving into some of the nuances here. But Linda, I can't help but be curious. We're talking about this convergence. We're talking about women being the primary care providers. I am sure, and I know you're a researcher, if you could discuss some of these statistics around the greater percentage of women caregivers, that would really help out, because I know they shoulder, in most cases, the primary caretaker role.
That's right. We don't have a slide, but we certainly do have the footnote. And the statistics they're staggering. They're staggering statistics around women as caregivers, around divorce rates amongst families with special needs kiddos, and around the chances of becoming disabled at some point during your life. So just bear with me as we run through a couple of these, really tremendously disturbing statistics, especially from the vantage point of being a woman. So the Institute on Aging reports 3 out of 4 caregivers are female, and they are likely to spend as much as 1.5 times more with the person they care for than would a male. We only have to look last year at the pandemic. By September of 2020, 650,000 more women had dropped out of the workplace than men. Some of you may have heard of the term she-cession instead of recession, and truly apparent during COVID. Women face, in addition to their normal domestic work and juggling jobs and kids, they faced 15 additional more hours of domestic work than men while they were stuck home working from home. With the schools closed, the women stepped in and had to do the homeschooling that was required. If we start to look around statistics around divorce, we know that having a child with autism increases the chance of divorce by approximately 10%. Anecdotally, we know that from COVID, families being quarantined together, divorce rates back up on the rise. Couples over the age of 15, there's been 100% increase over the last 25 years. Mental health challenges, mental health conditions are episodic. They can cause enormous stress in the household. There was a study by Wims and Pelham, which examined divorce rates of youth with ADHD. And here the divorce rate was nearly twice the divorce rate in the general population. 23% of parents of children with ADHD had divorced by the time the child was 8 years old, compared with only 12% of parents in the control group. And then if we look at risk of disability, this is straight from Social Security Administration. They publish statistics that suggest 1 in 4 people today are going to face a disability at some point in their life. And that means they face potential financial hardship at some point in their life. So those are staggering statistics. They suggest ever more important for women to get involved in the total financial planning, the total life care planning for their child with special needs. Don't just leave it to the spouse. Take it on yourself to the extent that you can.
Linda, thank you. Really overwhelming to say the least. Moving on to our second topic, insurance needs and creating an appropriate sound awareness of what is needed in this area. And Linda, again, I would like to kick it off with you. As you just indicated, women are clearly more likely to be the caregiver of a child or children with special needs. Now, what is the risk that women may run if they're underinsured, both from a life and a disability perspective?
That's right, big risk. So many people feel that insurance is too expensive. We would argue it's costlier not to have life insurance and disability insurance. And sometimes it comes down to your priorities. People are very quick to insure their cell phone, but what about their loved ones? You know, we just find people, it's easier to protect your things. But what it really comes down to is life insurance is actually a very inexpensive way to replace income from a parent who's in the workforce or for a parent who's a stay-at-home caregiver. It's replacement income that can materially and positively impact the care of your child with special needs. I mean, there's a couple of many different kinds of life insurance policies, and without going into them in great detail, there's whole life, which builds cash value. It provides lifelong coverage that's used more frequently to fund the special needs trust. There's term life, which is much less expensive. It covers 5 years, 10 years, 20 years. And it generally takes about 20 years to reduce debt, pay off your mortgage, build emergency funds, make progress towards saving, you know, for your future goals, like, you know, your retirement or your special needs trust. And then, of course, disability insurance gives policyholders a portion of their income should they become unable to work or they're facing serious illness. So, and something to keep in mind is just remember your risk of disability is actually higher than your risk of death. So, you know, these are things that are must-haves in the special needs planning world.
Great. I mean, we're just touching the surface, long-term care insurance, another issue as well. But I wanted to ask Leslie, what is the risk individuals or couples run if they do not have the correct beneficiary titling? I know people have grandiose estate plans, but what if the beneficiary titling is not correct, in particular for the child with special needs?
Yeah, Tom, it's so true. You can have a wonderfully drafted, very complicated will and a perfect special needs trust. But if you haven't coordinated those documents with all of the assets in your estate, including your non-probate assets that pass by beneficiary designation, then that child can still end up inheriting money outright, and the entire plan is basically blown. So when we have clients that are undertaking this planning, it's very important that we have a broad understanding of all of their assets, and that the clients understand what assets pass under their will and through their probate estate. Those are assets like a bank account entitled just in the decedent's name, the person who passes away, the person whose will it is. That will go through his probate estate. But there are other assets like the life insurance Linda is talking about, and also retirement plans. I mean, so many persons have a large amount of their wealth today in retirement plans and IRAs. Those all pass by beneficiary designation. So regardless of what your will says, your IRA and your retirement plans and your life insurance are going to go however the beneficiary designation is named. So we really have to be sure that we coordinate all of those to go into the supplemental needs trust. If we don't do that planning, and if the child inherits monies outright, then we can be in a much more complicated situation. We may be able to put that money into a more complex type of special needs trust, and that might be one that at the child's passing, there is a payback to the state for all of the Medicaid provided to the child over his lifetime. We want to avoid that by doing the preventative planning of the will with the supplemental needs trust. That trust has no payback to the state at all and can be drafted in a broader fashion than that other type of payback special needs trust. And I would note that under the new Secure Act, this is the act that limited the ability to get the lifetime stretch from an inherited IRA when an IRA is passed down to a child. There is an exception in that does say that if the traditional IRA is left to a properly drafted special needs trust, we can still get the lifetime stretch. So that's something that we're investigating with clients too, and it's really kind of changed the aspect of this type of planning. And then I just note, along with those non-probate assets, it's so important for clients to look for other assets that might be in the child's name, whether that's a joint bank account or if it's a bond that was purchased for the child many years ago. I see that happen a lot. Or if the parents had put accounts in the child's name early on. So those assets we might have to do special planning with as well.
Very good. Very, very good. Okay, moving on to the next topic. And I wasn't sure if you want to address this now, or we could address this later, Linda.
So, I mean, so this is sort of a slide about divorce and the complexities.
Yeah, so let's why don't we move on to divorce? Maybe we can reach back to this later. But because divorce is a far broader area, and we really want to touch upon that. So if we can move on to the next slide, please. Great. So our third broad-based topic today is really about pre, during, and post-divorce planning. And Linda, again, I'm going to turn to you to kick this off. But as a financial advisor, what are the potential risks that might be placed on a woman caregiver in the event of a divorce? Some of the unique issues.
Right. So first of all, this is, going through divorce is it's so traumatic. There's so much upheaval that often, people just want out of their marriage. They're just done, and they forget to place their child with special needs, front and center of the divorce discussions. And I know we breezed through that slide, but there is a legal versus a moral responsibility when a child reaches 18. And there are substantial differences between divorcing before and after. So one of the problems is with or without disabilities. After your child turns 18, children become legally independent adults, and parents don't really have the financial responsibility to support their child. I mean, in certain states, there may be an obligation to continue if the disabilities are so high. But I would say best case in an amicable divorce is that parents should try to cooperate. They should try to set up a special needs trust. And of course, as Leslie said, the money kept in the trust for a child doesn't count toward the low asset maximums. You get to keep your government benefits. Maybe another thing that parents can, try to avoid if possible. There are many alternative ways to get divorced now. And again, depending on what state you live in, but try to avoid litigation if you can. Litigation is so costly, and these are thousands of dollars that can be saved for your future savings and for your child's future savings. But I would say as a complexity, that said, often you have parents whose incomes are very, very different. There's great disparity in the couple's wealth, and sometimes because there is no real legal responsibility to continue supporting that child, even though a child is age 18, maybe chronologically 18, but still needs both financial and physical support. Sometimes you actually may have to use the full power of the law. You may have to take depositions. You may have to get the spouse who has the greater income to try to get in front of the court and have the court force the parent to continue supporting the child. And I would say other things are to keep really, really detailed notes about medical costs. I mean, surely a child at age 2, you can lift up a child at age 2, but what about a child that doesn't have much mobility and now they're 16? That's a very different medical it's a very different medical situation that you're facing. This list is kind of a checklist. Some Leslie's already touched on, but we try to have conversations with people who went through divorcing with children with special needs and have a look at some of the mistakes that they made. And so we already spoke about life insurance, but I mean, these are mistakes we see all the time. One of the things is to ensure that the divorce decree includes a provision that states the payer's life insurance will replace spousal support payments if the payer passes away. Otherwise, there's no legal obligation for the deceased parent's insurance to benefit his or her ex-spouse and the child. Another mistake we see is a husband agrees to purchase a life insurance policy, which is payable to his soon-to-be ex-wife. Well, if he passes away, what happens? Or if he cancels that policy after a year and no one's notified? So one thing we say is that spousal support recipients should own the life insurance policy. Owning the policy guarantees that the recipient would be notified if the ex-spouse isn't paying premiums. We touched briefly on medical and health insurance, but those are dramatically on the rise. I mean, I can say for our own family, between our premiums and the co-insurance and the co-pays and the deductibles, we're probably talking about $45,000 a year in just money straight out of our pocket. So have written into your agreement that healthcare has to be addressed in case of changes in employment or increases in the child's medical expenses. Another thing that we hope that we can work with people and to tell them is to keep a watch on your spouse's spending habits. Sometimes before divorce, we see one spouse taking on debt and hiding assets. So be aware of your spouse's spending habits. You can employ a forensic accountant to help uncover hidden assets and debt. Another thing we would say is be careful, especially if you're the spouse who has more money. Be careful about setting up joint bank accounts or joint investment accounts. Of course, if you're the spouse maybe who brought less income, you want to have visibility into your marital accounts, but just be aware that your partner can go walk right into a bank and pull money so easily out of a joint bank account. Just go ahead and see for yourself how easy it is. Leslie touched it already on estate planning. Parents are busy and sometimes they make some mistakes in their estate planning, leaving the money to the child instead of to the special needs trust. Educational decision authority, it's a big one. Sometimes the districts can see that there's a rift in the marriage and they try to divide parents. Sometimes a child's district special ed evaluation or outplacement can be delayed or threatened because one parent refuses to sign necessary documents. So make sure your divorce decree addresses educational decision-making authority. And I would say, you know, finally, there are other ways to protect a child around inheritance. You know, one thing we see is maybe a parent, a father, wife gets remarried, but then at some point in the future, they pass away and the new, you know, the new wife has first claim on the assets. So a divorce agreement, a divorce decree can specify in the event of death of either parent, most of the assets are going to be inherited by the special needs trust. And that clause you can insert into wills and into trusts as well. So those are just some real world problems that we've seen and to try to provide some real world solutions.
Very good. I want to turn this over for a second from the legal perspective too. Fantastic, Linda. Leslie, what are some of the best practices as an attorney you would provide a financial advisor if they have a client going through a divorce with a child having special needs? And I have a secondary question. We know that divorce rates by a lot of surveys are clearly higher for families that have a child with a lifelong illness or a death in the family. And may not be the staggering 80 or 90% we heard years ago, but it's clearly more than national averages. And when Linda analyzed it, it could be far higher in different areas. So knowing this, what are some of the strategies we need to think about?
Right. Well, I absolutely agree with all of the points that Linda just made. I think they were really, really excellent considerations for our clients. When a family is going through a divorce and there is a special needs child involved, there are so many additional considerations that the family needs to think about. And we want to address as many of those as we can in any property settlement agreement or in the divorce process. I understand that temptation to just leave the marriage and have it be done with, but these are just such important issues that will affect that child with special needs for the remainder of his life. So I completely agree with all of the things that Linda listed. In regard to the educational decisions, just another thing we like our clients to consider is to make sure that the residency for the school district is established in the divorce documents, again, to prevent fights down the road. Now, we do see in many cases, although it does vary state to state whether a parent would have an obligation to support a special needs child over age 18. Nonetheless, the parties can negotiate this in divorce decrees, and there are many cases in different states where support obligations have been approved over age 18. So if a family is going through a divorce, we would certainly recommend that the divorce documents clearly document the child's disability. Again, just to prevent a fight down the road if one parent says, well, my high functioning child with mental illness or high functioning autism actually can work and I no longer need to support that child. We want to try to prevent anything like that. If the child is still young, maybe the parents can agree or negotiate to provide for indefinite support. That way we're not leaving it to a court decision, but we have it in the documents, and that will provide support for that child as an adult. Once the child is over age 18 and the child begins receiving SSI himself, so that check hopefully for that $794 a month, the courts are very clear that that SSI check that the child receives should not offset any child support. So the parent's child support obligation should not change because of the child beginning to receive SSI. And that's something that I think clients need to be educated about. The parent's support obligation certainly could be changed by change of circumstances in the parent's lifetime. For example, if the parent retires and begins receiving Social Security and it does not have the same income, that might be a factor. But the child receiving money should not affect the parent's support obligation. And it's very important to understand that child support and also alimony are both considered income for Social Security purposes. So when the child is under age 18, 1/3 of the child support payment will be excluded, but 2/3 of it will be counted as income to the child. Many of our clients who have a minor child with disabilities, that child may not qualify for SSI under age 18 because parental assets and income are deemed to the child for purposes of SSI eligibility. After age 18, however, we're only looking at the child's money himself. So at that point, if child support is being paid, that child support is fully income to the child. It is unearned income, and after a $20 disregard, it will reduce that child's SSI dollar for dollar. So we want to do careful planning if we're going to have child support after 18, because we do also want to preserve eligibility for that SSI. So Social Security will allow us to make an irrevocable assignment of the stream of child support payments directly into a special needs trust. Now, it's not that same third-party funded trust that we were talking about. It is one of these payback special needs trusts. But that being said, we can assign the income to that special needs trust. The child can get the child support and still be eligible for benefits.
Very good. Very good. Yeah, I know it's far more complex not having seen this before, but a follow-up question, and it really leads us to our fourth area here. And Leslie, again, I'm going back to you back to back, but what is the appropriate process to put into place for couples that may share a dual guardianship? I mean, I can imagine this is a nightmare, but what is your perspective?
It can be. Yeah, it can be. So in many cases where we have a married couple, both spouses will be co-guardians. And generally they are able to work together, and that can be a good situation because both parents can make decisions. So if one parent can't attend the doctor's meeting, the other parent will be able to make decisions. So that is kind of the general way we see it being done. However, if that couple divorces, then we are looking at whether they can continue to agree on decisions for their child's best interest. So when couples are divorced, they certainly can still serve as co-guardians. When we have two co-guardians, each guardian has decision-making ability. So they each have, in the general guardianship, they each have full decision-making ability. Now, what happens if they don't agree? And as we know, some divorced spouses may not agree on everything. Unfortunately, in those cases, when they are fighting, we have to go back to court. And then the court is the one that is going to be making the decision. That is really the worst case scenario. One, it is expensive to keep hiring lawyers to go back in front of the court. Two, you are giving up complete control. The judge's decision may not be what you think is the best decision for the child. So we really want to avoid that at all costs. So there are a few different ways that we might try to break up the guardianship. One might be to name one parent as the guardian of the property. So this parent would have control over the child's finances. The court usually exercises a strict review of this. They may have to do accountings with the court. They may have to file periodic reports with the court as to what is going on with the finances. And there may be a limitation on how much they can spend without court approval. But nonetheless, that parent would have that control. And then the other parent could be appointed as the guardian of the person. this is the guardian that is going to make decisions such as where that child will live, the medical decisions, all of the lifetime decisions. So that might be one way to break it up. Another thing that we do in cases where we have a concern about whether the spouses are going to get along is that in the guardianship decree, we will appoint a third party as a mediator. So we will say, if mom and dad are not able to agree on a decision, then before they go to court, they have to go to this third party neutral mediator and present the problem there and see if it can be worked out that way. I have done that on multiple occasions, and I find that it can be successful and kind of a good deterrent to, just help the parents make a decision together so that they don't have to go down those next steps.
Leslie, your last slide here before turning it over to a question I have for Linda.
Absolutely. So when spouses are getting divorced, they certainly are each going to want to update their estate planning. In all likelihood, they are going to want to get new attorneys to do this as well. If one attorney represented both spouses while they were married and then they get divorced, then the spouses would have to consent to that same attorney continuing to serve. So in a lot of cases, they may want to get new counsel. But reasons that they may want to get separate estate planning is that they will want to modify their wills, but they may each want to do two separate special needs trusts. Both spouses may want a separate special needs trust. That allows the spouses to name different trustees if that's what they would want, and also different contingent beneficiaries who might inherit any monies once the special needs trust ends. So in many cases, that is what spouses will do.
Yeah, overwhelming. Linda, I did have a question for you. I know we don't have a slide for this, and I know based on your background, it'd be really helpful from a financial planning cash flow perspective. What are some solutions to potential problems that might arise from these dual guardianships and other issues we discussed?
Well, I think in some ways we've already touched on that, Tom. I mean, we've given a few solutions to life insurance, which we see over and over and over as a mistake. But I think one thing that's very, very important when it's not an amicable divorce, and there's a special needs child, and you've got escalating medical costs, and you have a parent who basically has to now take off, can no longer work because they're the full-time caregiver, is really to document everything. I mean, I say keep two books, a book of all your good behaviors, a book of all your spouse's bad behaviors, because you may need to go back to the courts and get more support for the child. I mean, again, what's happened with health insurance now, there seems to be really no solution in sight. Healthcare costs just keep going up every single year. And so I just tell people to document, a little journal by your bed, spend 5 minutes, a few entries, each day on the good side and the bad side, all that you've done as a wonderful parent and all that your spouse hasn't done to support your child with special needs.
It's a lot. Now, we still have a few minutes open, and we do have a few questions from the audience I think Brooke has been accumulating. I don't know, Leslie, if you want to address some of these questions now, or if time permits, Linda, you can address a question or two, but they appear under the Q&A.
I'm going to jump in and ask Leslie one, because I think this might be for Leslie. Who has ultimate decision power, POA or trustee?
Okay, so the trustee is going to have ultimate decision-making power over any monies that are inside the special needs trust. The trustee controls that. The power of attorney would have ultimate decision-making authority, or the guardian, if the person wasn't competent to do a power of attorney, they would have decision-making authority over assets outside of the trust.
Now, there's a follow-up to that too, Hillary, which is interesting. can you address the need for a trust protector, Leslie?
Sure, sure. A trust protector is generally a third party, so usually somebody other than the trustee, but the trust protector can have additional powers in regard to the trust. And it'll depend on how the trust is drafted, but an important power that they can hold is the power to remove the trustee. So if there is a corporate trustee in place, if a bank is the trustee, we may very well want to use a trust protector just so that there is another party that can remove that bank if they, change hands and it's no longer a small town bank that mom signed up with, or if there's a trust advisor there that we just aren't comfortable with. So that's a really important thing to include in these trusts, because special needs trusts last for the person's lifetime. So that's a long, time, and it's important to include as much flexibility as we can in them.
Very good. Now, I wanted to mention, Linda, I don't know what your feelings are on long-term care insurance. We have a couple of questions regarding long-term care, pretty broad. For example, Tom is asking what your thoughts are on long-term care insurance, and Mark has a ancillary question saying, well, what about long-term care needs for the parents? Who will take care of the caregiver?
Right. So in the brief discussion around insurance, I didn't touch on long-term insurance, but having just lost both of my parents my mom recently to Alzheimer's and dad to a heart infection and a stroke, and paying privately for their caregivers. They probably went through $250,000, $300,000 a year. Long-term care insurance is not terribly expensive. Again, it's back to this, many people think insurance is very expensive. It's tough to pay for something you may or may not use, but life expectancy is just staggering numbers. We were in 1776, the year of our founding fathers, average life expectancy was 35. Fast forward 100 years, it was only 40. Fast forward another 100 years, it was only 75. Well, from 1976 to 2020, you have a 50% chance of living to your 90. So long-term care insurance is a very good option. And again, not terribly expensive. It's a must as part of your overall life care planning for your child and also for you and your spouse.
Wow. And just I hate to say this, but Leslie, someone's asking a question, just more of a repetitive nature, because I know you breezed through it quickly. The question is, can Leslie explain about the 1/3 of the payment excluded? I believe that's regarding child support. Mm-hmm. So if someone is a minor receiving child support, or they're age 18, full-time college student up to age 22, how does that 1/3 rule work again?
Let's just keep the math simple for me, Tom, if you don't mind. I'm not the accountant like you. But if, for example, a parent is paying $300 a month of child support, if that child is under age 18, 1/3 of that will be excluded. So only $200 will count towards that child's SSI eligibility. Over age 18, the full $300 is counted against that child's SSI eligibility. And again, that is unearned income to that child or the adult child. And that means that $20 of it is disregarded, but then $280 of it will dollar for dollar reduce the amount of SSI they get.
What a phenomenal planning aspect, because if you have one individual paying child support of, let's say, $815, then that child is disqualified from SSI.
Correct. Unless we assign the stream of payments into a special needs trust. So it's just so important to do that as part of the divorce process. It needs to be done by the divorce court at the time of the divorce. Mm-hmm.
It can't be similar to a like-kind exchange where someone decides after the exchanges, the subsequent acquisition and disposition have occurred. By the way, I was thinking a like-kind exchange. You can't do it after the fact.
No, you can't put the toothpaste back in the tube. No.
Now, there's another question, which I believe is really up your wheelhouse. Lynn says, any opinions on a specialized corporate fiduciary Hope Trust. Is that something you're familiar with, Linda?
I am not
Okay.
familiar. I mean, in general, what I say to people is over the issues of trustees and guardians, there's a great temptation to pick, your sibling, your best friend, and all of a sudden life goes on, and all of a sudden your sibling, your best friend, they're in their 60s, their 70s. First of all, you want to pick someone as young as possible. Maybe one of your children, maybe your young adult children can take, your other young adult children can take over. Maybe they have some friends, or your friends have, capable young adult children. But try to choose someone who's significantly younger than you. And then two, always better. Corporate trustees certainly have their place, but they're expensive. They're never going to have the same, love and interest in your special needs child. And, if there's a solution to find someone inside your world that's willing to serve as a trustee over, finding a corporate trustee, and you can even pay, your friend's child a little bit of money. It's just much simpler, if possible.
Now, just one more question, and I haven't seen this question before, and Leslie, again, it goes back to you. It's on third-party SNTs. The question is, if you have, I just lost it, if you have two third-party SNTs with different remainder beneficiaries, which one of the trust would pay benefits first?
It's a great question when we have divorced spouses. Would you believe I have this situation right now? And the arrangement that we worked out, and we worked with the trustees to do this, but we actually created a third special needs trust. And each special needs trust is paying an agreed upon amount each month into this third trust, which is then used for the child's benefit. It's
pretty good. That's a good idea.
Yeah. Now, luckily, the ex-spouses in that case get along, and the trusts are similarly funded, but that's what we're doing.
Very good. Now, there are other questions, but I think we're really right up against 3 o'clock right now. If a question has not been answered, we will share them with both Leslie and Linda. But Linda, Leslie, thank you very much for your time today. I'm sure everyone here appreciates it.
Yeah, I echo Tom's thanks, and I want to thank you all for joining us today. Thank you especially to Leslie and Linda, who again have offered to connect with all of you. Their LinkedIn information is on the page. We just want to mention the college's Chartered Special Needs Consultant Program, and this is designed for people who want to learn more about supporting families caring for a person with special needs. It's a 3-course program, certainly worth exploring. And there's more information on our website, theamericancollege.edu/designations-degrees-CHSNC. So thank you again today. We welcome your feedback from this event. We encourage you to connect with Leslie and Linda and Tom for more insights. And thank you all for joining us today.
Thank you.
Thank you.